Thank you so much. I will call this meeting of the Senate Judiciary Committee to order. Would the esteemed secretary please take the roll?
Vice Chair Canizaro.
She's on her way. Please mark her present when she arrives.
Senator Orenshaw.
Here.
Senator Harris.
Please also mark her present when she arrives.
Senator Settlemyre. Senator
Please mark
Hansen.
Senator Settlemyre.
Senator Hansen.
Senator Hansen's here. Sorry, we're going over the bills real quick. Senator Settlemyre and Senator Pickard are also rushing back to their rooms.
Okay.
Sorry.
Senator Pickard. Chair Scheibel.
Here, we are going to start in a subcommittee of the Senate Judiciary, seeing as we have 3 of our 7 members present, and I completely understand it is exactly 1 o'clock, but I want to get started on time because we have such a long agenda. And we also have our staff members here with us, Nicholas Anthony from the Legislative Council Bureau. And I actually don't see Pat Guinan with Legislative Council Bureau, but go ahead and add him to the record because I'm sure he's on his way. With that, as you all know, we have a very packed schedule. We have 4 bills to hear. We have, I think, 11 bills to work session. So we will go back and forth between the 2 and get all of this done. If the record could please reflect that Senator Canizaro is now present. And I am going to open up the hearing on SB 313.
Thank you very much, Chair Scheibel and members of the Senate Judiciary Committee. For the record, my name is James Orenshaw. I represent State Senate District 21. That's parts of Henderson and unincorporated Clark County. Thank you for hearing Senate Bill 313 today. It's important to understand that children who are arrested and charged with crimes are much different than adults in the adult criminal court system. Those children lack mature judgment. They also have a greater capacity for change, for positive change. Our juvenile justice system maintains rehabilitation as its primary goal, and thus is different from the adult criminal justice system in many ways. This bill here before you, and I actually, Chair and members of the committee, I'd like to point the committee to a mock-up amendment on Nellis. I have been able to reach out, and I appreciate the help of Bridget Duffy from the Clark County District Attorney's Office. And I believe there's a mock-up amendment that should be on Nellis, which represents agreement, at least between maybe not all the stakeholders, I'm still working on that, but between Ms. Duffy, Clark County District Attorney's Office, and all the other stakeholders that are working on this legislation. With your permission, Chair, I'd like to just briefly go over a couple of the highlights of the mock-up amendment, and then I'd like to turn it over to Attorney Christina Wildeveld, who I believe is on the Zoom, or should be on the Zoom soon, and she would speak a little more to the bill and the mock-up. Senate Bill 313, under the proposed mock-up, would prohibit a youth being committed to a correctional facility if they are found not competent. This bill would also allow a youth found to be not competent to request that their records be sealed. It reduces the time that a youth must be under supervision of a juvenile parole or juvenile probation officer from a minimum of 3 years to a minimum of 1 year. It's currently 3 years if the youth is adjudicated for a sexual offense. It also requires the court to consider specifically whether a youth would be a danger to commit a sexual offense in the future to determine whether that youth should face registration as a sex offender. I believe that these provisions would enable greater rehabilitative efforts within the juvenile justice system using developmentally appropriate strategies rather than what we currently have in the statutory scheme. With your permission, Chair Scheibel, I'd like to turn it over to Christina Wildeveld, who I think is on the Zoom, and then I'd like to answer any questions.
Absolutely. Go ahead, Ms. Wildeveld.
My computer's not up yet. I missed everything that was just said.
You're presenting the mock amendment to SB 313.
Good morning or good afternoon, chair members. My name is Christina Wildefeld. I think we're talking about 313. We've already discussed the amendment. Is that where we're at?
No, you're presenting the amendment.
Thank you. The juvenile system and the adult system are entirely different for numerous reasons. Nevada's formal juvenile justice system is established, for the most part, by Chapter 62 of the Nevada Revised Statutes. All juvenile matters, regardless of the nature of the charges, are considered civil offenses. Therefore, the Nevada Supreme Court has ruled that constitutional and statutory provisions related to criminal procedure are not applicable to proceedings in juvenile court, which are not criminal in nature. Instead, the focus and function of juvenile court is both rehabilitation and community safety, but consistently recognizes children as children. This bill makes a number of necessary and positive tweaks to current laws as they relate to the juvenile justice system, so that the separation between juvenile laws, which are civil in nature, and adult court, which is punitive in nature, remain just that, separated. Under existing law, so with regard to the amendment, we have agreed that we are going to delete section 1 and 2. And so section 1 and 2 as is, and then section, so there would be no changes to section 1 and 2 of the proposed bill. Section 3 will be kept as is. I think everyone agrees that section 3 is a needed change. And then section 4, 5, and 6 will be kept as is. So under existing law, a child who commits a sex offense must have at least 3 years minimum of supervision by the juvenile sex offender probation officers. Section 4 of the bill modifies this to a minimum of a 1-year term. Currently, the juvenile sex offender court, unlike other juvenile courts, operates by statute as a one-size-fits-all model. A child in JSO court will be placed on 3 years of probation for everything from pinching your peer's butt on St. Patrick's Day to taking a nude selfie or sexting, to the extreme cases of unwanted sexual penetration. This modification will allow all parties more discretion so that the exploration and experimentation cases can be treated differently than those of a more predatory and abusive in nature cases. The bill will eliminate this one-size-fits-all operation and give all parties more discretion in the treatment. Section 5 and 6 of the bill does not mandate that a juvenile sex offender be required to register as a sex offender like the adult has to. Instead, the court will be granted the discretion to determine whether a child poses a future threat or danger to the community, which will then subject the child to future registration and community notification as a sex offender. As we currently operate in juvenile sex offender court, parties negotiate cases, that's the district attorney and the defense attorneys, we negotiate cases so that the child will not be subject to adult registration for delinquent acts they committed as a juvenile. Taking this mandate from the courts, where the court is required to have them register as an adult sex offender, and have future supervision and notification provisions, and will only do that if the offense is so severe that in the rare cases that the parties believe that the child will forever pose a threat to the community. This provision puts the discretion back in the court's playbook and changes the standard to only requiring future notification if there is a threat to commit subsequent sexual offenses by the juvenile. The bill will also add a provision that juvenile sex offender cases cannot be sealed for 3 years. So unlike other cases that we have discussed in previous bills, if you're in juvenile sex offender court, there will be that 3-year waiting period in order to seal their cases. We urge you to pass SB 313 to make the necessary changes in the current statutes for those of us who work in the system and navigate the courts and the laws. And to clarify and give guidance statutorily as the laws were intended to accord with the operation of juvenile court while maintaining the integrity of the two different systems. The changes are beneficial to not only those of us who practice there, but also to the court and the community it serves. Thank you.
And Chair Scheibel, James Orenshaw against State Senate District 21. Certainly, I think that brain science in terms of the child adolescent development has improved leaps and bounds from when a lot of these statutes were originally put on the books. I think we know a lot more about you know, the immaturity of youth in terms of a lot of these decisions. And I believe that the changes recommended here in the mock-up would help bring Nevada statute in line with what we now understand about a lot of youth who end up in the delinquency system. I'm happy to answer any questions.
All right. It looks like we have a question from Senator Pickard. Go ahead.
Thank you, Chair Scheibel. I have a whole list of questions that were all answered by the amendment. Excuse me. So the last question I have, and I will just comment that I agree completely. We know much more about how the brain develops, and how the last thing to develop is the prefrontal cortex or the judgment center. In fact, that doesn't fully develop until our mid to late 20s or early 30s. So we know that when children are acting, they literally have half a brain and they act like it. So I think that it's important to be able to retain the ability of the court to sequester kids when they're a danger to themselves. I like the amendments. The one thing that concerns me is oh, wait a minute. I think this is on the next bill. Is the mental health piece on the next bill? On 317?
Chair,
Or is it in this one? Where we're requiring all the employees to, I just can't put my finger on it. So now I'm concerned that maybe I'm conflating the bills.
And Chair, to you and through you to Senator Pickard, I believe that's the other bill.
Okay, sorry. Then I apologize, Madam Chair. My questions have been answered. Thank you.
All right. Thank you. We will move on to Senator Hansen.
Thanks, Chair Scheibel. I don't know, the half a brain argument is kind of an interesting one. My concern with the bill is frankly, I want to, if we're going to err, we're going to err on the side of protecting victims, right? And striking out the idea that the safety of others and making it strictly a sex offense makes me a little uncomfortable. So I don't know if that's, to me, it'd be better to have a little broader discretion for the courts and not just limit it to sex. Because when you think about it, if we're going to go with the argument that they have half a brain at this point, but when you're 18, at least a male, you got full libido. So those are a bad combination in some cases. And I can't help but say, it's ironic that we're going to be insisting on considering them undeveloped brain-wise till they're 25 or whatever, yet we allow abortion without any parental involvement at all, which is just crazy since it's a medical procedure, never mind the arguments about the morality of it. Anyway, my question is, why are we striking out the verbiage, the safety of others, and making it much more specific, commit a subsequent sexual offense?
And Chair, to you and through you to Senator Hansen, James Orenshaw, State Senate District 21. We're looking at these statutes. Well, let me preface that. I know we've talked a lot about the adult criminal court system versus the juvenile criminal court system. And in general terms, the adult criminal court system is based more on punishment for the crime, making the victim whole, whereas the juvenile justice system is a model based more on rehabilitating the child, trying to make sure that whatever services, treatment, therapy would try to prevent that child from ever being in that same situation where they commit that delinquent act from happening again. And here, certainly looking at the changes I'm recommending in this mock-up amendment, where a potential consequence for a child who is charged with a juvenile sex offense could be registration as a sex offender, I'm recommending in this bill the change to the threat to commit a subsequent offense as opposed to the threat to commit some other delinquent act, because the consequences could be registration. And when we're trying to have a child end up on his or her feet and not really get caught up, and we're trying to strike a balance of protecting the community, but also trying to get the child the services, the treatment, the therapy they need so that they don't ever end up in this situation. And certainly I think that many of the children who are charged with juvenile sex offenses have themselves been victims. Many of them have been victims of molestation. And that's where sometimes these patterns are picked up. But once those kids go through the treatment and the therapy for juvenile sex offenders, the recidivism rate is remarkably low, I believe, across the country and in Nevada. For kids who go through, they get the therapy. There's so many modules they have to complete. And so it's very successful, the treatment for those kids. And, you know, a child who's accused of this kind of offense is really much different than an adult who's charged with this kind of offense. And if I share with your indulgence, if I could turn it over to Ms. Wildeveld, because I'm sure she can add some more points a lot more eloquently than I can.
Thank you, Senator, Chair Seibel, and Senator Hansen, for your question. Currently, as I indicated, there's a one-size-fits-all model in the juvenile sex offender court, as I have argued many times before Senator Picard's wife in court, that not all cases have to be not all kids have to be on probation for the 3 years that are required of them. Most cases, and a lot of the cases, are exploratory and experimentation, and they're brought into that court for those reasons, because they're caught doing something or they say something to a counselor and they're brought in. It's not an ongoing abusive relationship. Instead, it's a one-time or act, or just through the exploratory experimentation process. Yet those kids are all treated the same. And as Senator Orenshaw indicated, there is a very rigid process that the kids go through in a juvenile sex offender court. The whole reason for the court is to make sure that when they're an adult, that action never happens again. So there's alternatives like boundaries classes, so kids can learn what the proper boundaries are with their peers, that they have to learn what is right and what is wrong, because perhaps their parents aren't teaching them, or they're just not understanding what the proper boundaries are with their peers. And those cases don't need to be on juvenile sex offender probation for the 3-year period. In addition, as the way it currently stands is that prosecutors and defense attorneys are negotiating our cases, taking it out of the judge's hands, negotiating our cases, so that should the child not be successful or need more time, or something happens during the course of the case because they were previous victims of molestation or something else, we're negotiating the cases to a charge that will not allow them to become an adult sex offender. So this amendment and this change in this bill puts the discretion back in the judge's hands, so the judge can determine which children need to be on longer periods of probation rather than the 3 years, or which kids can just be on the 1 year and they're complete all requirements and get through it and move on with their future successfully. Thank you. I hope that answers that.
It did. Thank you very much. Last question, Senator Orenshaw. Bridget Duffy's on board with this?
Chair, to you and through you to Senator Hansen, I appreciate Bridget Duffy and Mike Watson of the District Attorney's Office have worked very closely with me, Christina Wildeveld, Jennifer Frazier of the Clark County Juvenile Public Defender's Office, and I believe that the mock-up amendment represents consensus. I think someone from the District Attorney's Office will be speaking later, but I believe this represents consensus, at least with the Clark County District Attorney's Office.
Very good.
Think
Very
there's
good.
still work with Washoe
Thank you,
County.
Senator. I'm sorry. Thank you. Thanks, Madam Chair.
Thank you.
Absolutely. Any other questions on SB 313? All right. Not seeing any, we are going to move to testimony. I do see that we have a number of people queued up to testify. Not sure if you're here on this bill or another bill, but with the deadline approaching and our long schedules, I would like to remind everybody that it is perfectly acceptable to get on the phone, give your name, and just say ditto. It was good enough for Patrick Swayze and Ghost. It is good enough for us in this committee, and we will understand that you agree with the previous presenters and it allows more people to testify. With that, I will move to support in SB 313, support for SB 313.
Thank you, Chair Scheibel. Are we going to the phones? I apologize.
Oh, yes, unless there's any, yes, going to the phones.
Perfect, thank you so much. To testify in support on Senate Bill 313, please press *9 now to take your place in the queue. Once again, to testify in support on Senate Bill 313, please press *9 now to take your place in the queue. Caller with the last three digits 080, please slowly state and spell your name for the record. You will have 2 minutes to speak and may begin.
Hi, Jim Hoffman, Nevada Attorneys for Criminal Justice. NACJ supports SB 313. We believe these changes are helpful in ensuring that the juvenile justice system is administered in a fair and effective manner. In particular, we believe that incompetent children with mental health issues should not be held in correctional facilities. They should be treated to resolve their issues rather than be punished in a way that exacerbates those issues. SB 313 addresses this problem as well as a few others, and so we support this bill. Thank you.
Thank you, caller. Caller with the last three digits 611, please slowly state and spell your name for the record. You will have 2 minutes to speak and may begin.
Good afternoon, Chair and members of the Senate Judiciary Committee. This is John Pirro, John Piro, from the Clark County Public Defender's Office. We'd like to thank Senator Orenshaw for bringing this bill forward and Ms. Wildeveld for presenting the bill with them. We're grateful for all the efforts and striving that they're doing in the juvenile justice arena and working with all the stakeholders involved to make it the best bill possible. Thank you.
Thank you, caller. A reminder, we are currently on support testimony for Senate Bill 313. If you'd like to provide support testimony at this time, please press *9 now to take your place in the queue. Caller with the last three digits 882, please slowly state and spell your name for the record. You will have 2 minutes to speak and may begin.
Good afternoon, Chair Scheibel and members of the Senate Judiciary. This is Bridget Duffy, Brigid Duffy, Chief of the Juvenile Division for the Clark County District Attorney's Office. And I am speaking today on behalf of the Clark County District Attorney's Office. I am coming in support of SB 313. We appreciate the sponsor and all of the other stakeholders taking in our consideration of for the amendment, and believe that this is a bill that will be able to work to both look after our children and protect our community safety. Thank you.
Thank you, caller. For those of you that just joined the call, we are currently on support testimony for Senate Bill 313. If you'd like to provide support testimony at this time, please press *9 now to take your place in the queue. Caller with the last three digits 318, please slowly state and spell your name for the record. You will have 2 minutes to speak and may begin.
Good afternoon, Chair Scheibel and members of the Senate Judiciary Committee. This is Kendra Birchie, DERTSCHY with the Washoe County Public Defender's Office. We just wanted to put our support for this bill on the record and appreciate all the hard work of the stakeholders to protect our children. Thank you.
Thank you, caller. Caller with the last three digits 956, please slowly state and spell your name for the record. You will have 2 minutes to speak and may begin.
Good afternoon, and thank you, Chair. For the record, this is Liz Davenport, LIZDAVENPORT, on behalf of the ACLU of Nevada in support of 313. Thank you so much, Senator Orenshaw, for bringing this bill. I'll merely say ditto and want to echo what all of our partners have previously stated. We definitely support juvenile justice and rehabilitation and reintegrating youth back into the community, and believe that this bill puts that forth.
Thank you, caller. As a reminder, we are currently on support testimony for Senate Bill 313. If you'd like to provide support testimony at this time, please press *9 now to take your place in the queue. And Chair Scheibel, at this time, there are no more callers to give support testimony.
All right, thank you. We will now open it up for testimony in opposition to SB 313.
Thank you, Chair. To testify in opposition on SB 313, please press *9 now to take your place in the queue. Once again, to testify in opposition on Senate Bill 313, please press *9 now to take your place in the queue. And Chair, at this time, there are no callers to give opposition testimony.
Thank you. We will move to testimony in the neutral position on SB 313.
Thank you, Chair Scheibel. To testify in neutral standing on Senate Bill 313, please press *9 now to take your place in the queue. Once again, to testify in neutral on Senate Bill 313, please press *9 now to take your place in the queue. And Chair Scheibel, at this time, there are no callers to provide neutral testimony.
Okay, thank you for your help. Since we are tight on time, I'm going to go ahead and close the hearing on SB 313 with thanks to our presenters, and invite any committee members or people following along in the audience to follow up with them offline if you have further questions or comments. And at this time, I will open up the hearing on SB 317. Senator Orenshall, whenever you're ready.
Thank you very much, Chair Scheibel. James Orenshall, I represent State Senate District 21, parts of Henderson and unincorporated Clark County, presenting Senate Bill 317. There should be a mock-up amendment on Nellis, and Chair, I apologize, that mock-up amendment has scrivener's error, and I'm the scrivener, and it was my error, and there should be a corrected mock-up being posted, I hope now, but if not, it will be circulated. I'll try to make sure it gets circulated through email. But Senate Bill 317 represents an effort to try to reach fair conditions for employees of the juvenile justice in Clark County in terms of some issues that they are concerned with. And here, before I get too deep into the weeds, I want to thank the representatives of NAPSO and of Clark County who have worked together with me, and we've had a lot of meetings, a lot of talking back and forth, trying to get this bill right. There is agreement in terms of trying to clarify the language in Section 1 as to the 180 days, that should be after arrest, not after arraignment. The current language in the statute, I believe, is murky and needs clarification. And with that being said, Chair, I'd like to turn it over to Matt Richardson, who will help me present the bill, and then I'm happy to answer any questions. And hopefully the corrected mock-up amendment should be posted if it's not already posted.
Yes, our fantastic committee manager is working hard to get that posted, and we are eternally grateful to her for her continued service. And we'll go ahead and turn it over to Mr. Richardson to start walking us through the bill and the amendment.
Good afternoon. First, I'd like to thank the chair, Ms. Scheibel, and also thank the Committee on Judiciary for the opportunity to speak today on Senate Bill 317. My name is Matt Richardson. I'm with the Juvenile Justice Supervisors Association and the Nevada Association of Public Safety Officers. I'm a juvenile probation supervisor in the detention division. Juvenile officers and supervisors are not your typical law enforcement officers. They have to be quasi-law enforcement, social worker, mentor, caseworker, and tirelessly connect families in need with anything that might work for that family to get on the right track. While the youth might be on probation, we provide services to the entire family. Now, my peers and the officers I work with, they're outstanding individuals that work with the most troubled youth. These youth charges normally are gun-related, typical robbery, assault, and sexual offenses to the extreme of murder and kidnapping. Now, the officers that I work with and myself are not perfect. We may end up at the wrong place at the wrong time. We may get caught up in a bad situation with a friend or relative. Now, we also may be falsely accused of a crime as well, or be accused of child abuse or neglect. What this bill does is give us some fairness for due process. In working through our due process and the justice system, juvenile probation officers, juvenile probation supervisors, and employees of juvenile justice services should be given the same rights that are afforded to other officers. This right is upon the outcome of criminal prosecution, and the department shall award the employee back pay for the duration of the unpaid leave in this bill. Now, NRS 289.092 already gives officer this right. However, there is a language dichotomy. The dichotomy is that in 289.092, it says that if the agency suspends an officer without pay pending the outcome of a criminal prosecution, then the law enforcement shall award the officer back pay for the duration of the suspension. Now we're looking for the language placed on leave without pay. And the reason we're looking for that dichotomy is the county and our agency do not find the word suspends carries over to the Department of Juvenile Justice Services. They believe that there is a dichotomy between suspend and placed on leave without pay. Therefore, we would like to codify in law that the employees of Juvenile Justice Services are given that right under 62G. Also, now this isn't a solution looking for a problem. This has happened in the Department of Juvenile Justice Services, in which an employee was charged with a crime. Upon the resolution of his case in which he was cleared of any charges, the department waited an additional 5 months to bring him back to work. Now, he was placed back at work, but without back pay. During that time, he had to come up with different avenues for pay, borrow money, make loans, get caught up or get put back on his mortgage and rent, and put in financial despair. We would just like to first thank Orenshaw for sponsoring this bill. I think it's a fairness bill for the officers, and I just appreciate you hearing us out.
Chair Scheibel, if I could just jump in, I just want to kind of jump in on what Officer McCann stated. When a child is brought to a juvenile detention center, arrested by law enforcement, whether it is painting a wall with graffiti or something much, much more serious, it's a very scary, scary thing. And I have been moved in terms of some of the juvenile probation officers, juvenile detention officers I've seen, in terms of the kind of nurturing and mentoring I have seen so many of these officers give to these scared kids who are in Clark County Juvenile Detention Center. I want to take my hat off, to Jack Martin and to Mr. Wellahan at Clark County in terms of great work they've done, because yes, it's a scary experience, but there's so many caring officers there who do care about these children and want to try to see them land on their feet. And I think what Officer Richardson said about some of these officers being quasi-social workers is very true. I know that there's a unit there of officers who try to take kids to get their identification, get enrolled in accelerated classes to try to get their GED or diploma, because a lot of them, have dropped out of school or been kicked out of school. So, not to, and I believe they deserve the same protection that other officers do when they're accused of something that's breaking the law, and they're able to prove, that is not the case. I'm happy to try to answer any questions, Chair.
All right, we have a question from Senator Pickard. Go ahead.
Thank you, Chair Scheibel. Now we're on the question I wanted to get to last time. I think it's important to make a distinction that we're not talking about the kids in detention. We're talking about the adults. And as I understand the bill, this is seeking to deal with an employee who has been placed on leave without pay, which I understand, at least from my own experience in family law cases involving officers, that when they're put on leave without pay, it's usually because there has been an internal investigation and there is probable cause to believe that they have either committed a crime, violated the rules of their procedures, or both, and that the leave without pay is intended to be essentially a preliminary action taken against them. So it's not without cause, it's not without some investigation, and that they are suspended per the CBA without pay. Is that a correct assumption?
Chair Scheibel, 2 and 3 to Senator Pickard. May I defer that question to Officer Richardson, I believe he's better suited to answer that.
Sure, and let me just qualify that. I didn't mean suspension because that's a disciplinary action. I meant they're put on leave without pay, and it was intended to be without pay from that point on.
Yes, to the chair, to Senator Pickard. Now, the agency conducts their investigation after the criminal investigation concludes. So this is about being on the criminal investigation. And so after the end of the criminal investigation, if an employee is cleared of the charges, then they're given back pay. Now, the agency can conduct their investigation on the conclusion of that criminal investigation, sir.
Yeah, I'm sorry, and I probably wasn't clear. I meant before the criminal investigation is concluded, and I was going to get to the back pay here in just a second. But when they're initially put on leave, that's because they are facing criminal charges, they've been arrested, and there's lots of different reasons why an officer could be put on leave. In my experience, most recently, it was an officer that had violated their use of force much, and this is in the public domain, right? He violated the use of force rules, and so he was put on leave while that investigation, and I don't believe that any criminal investigation occurred. So it doesn't necessarily mean a crime has been committed, though in this context, that is the case, right?
For the record, Matt Richardson, to the chair, through the chair to Senator Pickard. Sir, yeah, you're accused of a crime. You're arrested, and we're just saying that if the charges are cleared and, you're found not guilty, you've been falsely accused, whatever the circumstances, that the charges go away. Upon the criminal charges leaving, then you're returned back to work with full pay. So it's not that if you're convicted, you will come back with full pay. It's just only upon that.
Yeah,
now,
I'm sorry. I'm probably just struggling to be clear. I'm talking about prior to adjudication as to the criminal action. They're put on leave. And my understanding is under the current CBA, once they are put on leave, they are not supposed to be earning an income. They're not supposed to be receiving an income by that agreement until the criminal charge is completed. That under the current state of the law in the CBA. Is that accurate?
Yes, sir. I think it is. But the Matt Richardson, to the chair, to Senator Pickard. I believe that is accurate. However, the agency does not conclude their investigation until the conclusion of the criminal investigation.
Right.
Sometimes if they conduct a simultaneous investigation, then one or the other will become tainted. So there's one after the other. They're not, done concurrently, and the criminal investigation takes precedent.
Sure, and that makes sense. And so I wanted to make sure that my understanding was correct, because it leads to the next question. If the current CBA and the current status of the law is that when an officer is suspended pending a criminal investigation, whether or not they're guilty, right? Because they could, or they may or may not be. I don't know what the statistics are, but it doesn't really matter. They are not supposed to. The intent is to suspend their pay. And as I look at in Section 1 sub 5B, they can elect to use their vacation time and the like, sick leave, whatever, their paid time off during that period of leave, even though the CBA contemplated that would be suspended because they would potentially lose that if they are convicted. So in other words, if, say, we look at the other side of the equation, say they are guilty of the crime, we're paying the criminal even though the CBA expressly allowed for the suspension of that pay, right?
Yes. However, the amendment that you're talking about the pay has been removed. We moved the removed the portion, and so we agreed excuse me, this is Matt Richardson for the record to the chair, through the chair to Senator Pickard. We removed that portion of the bill. We also came to an agreement on when the timeline would start. We agreed that it was from time of arrest, not time of arraignment. That second portion has been completely removed. And so now all we're really dealing with is whether or not, if you're clear to the charges, you receive the back pay.
All right, I apologize. I did not see that in the amendment, which I didn't have before we started today. So, all right. Then my last question, let me see if that resolves it. Madam Chair, if I have another question, I'll ask it, but we can move on. I think this may have resolved it. Thank you.
Thank you, appreciate that. Are there other questions from members of the committee? Not seeing any, we will move then into testimony in support of SB 317.
Thank you, Chair Scheibel. To testify in support on Senate Bill 317, please press *9 now to take your place in the queue. Once again, to testify in support on Senate Bill 317, please press *9 now to take your place in the queue. Caller with the last three digits 200, please slowly state and spell your name for the record. You will have 2 minutes to speak and may begin.
Good afternoon. My name is Darren Dimaya, D-A-R-R-E-N-D-I-M-A-Y-A. I would like to thank the chair and committee for the opportunity to speak on Senate Bill 317. I'd like to show my support for Senate Bill 317 on behalf of the Juvenile Justice Supervisors Association. Thank you.
Thank you, caller. And as a reminder, we are currently on support testimony for Senate Bill 317. If you'd like to provide support testimony at this time, please press *9 now to take your place in the queue. Caller with the last three digits 683, please slowly state and spell your name for the record. You will have 2 minutes to speak and may begin.
Good afternoon, Madam Chair and members of the committee. My name is Rick, R-I-C-K, McCann, M-C-C-A-N-N, and I'm the Executive Director of the Nevada Association of Public Safety Officers and a member of the Nevada Law Enforcement Coalition. I am here today in support of SB 317. I'd like to thank Senator Orenshaw and Mr. Richardson for their work with the stakeholders from Clark County to resolve about 2/3 of this bill, as you can see from the mock-up. The remaining part simply deals with what we consider to be the equity of reimbursing an officer who has been placed on leave without pay. That's the term the county uses in these situations, leave without pay, not suspended, for a criminal charge that is ultimately dismissed. That's only fair in an attempt to restore the officer in some way for their successful defending of themselves against unprovable criminal charges. That having been said, I'll keep it brief. We fully support SB 317 with its amendments. Thank you very much.
Thank you, caller. And as a reminder, we are currently on support testimony for Senate Bill 317. If you've just joined us and would like to provide support testimony at this time, please press *9 now to take your place in the queue. And Chair, at this time, there are no more callers to provide support testimony on SB 317.
Okay, we will now open it up for testimony in opposition to SB 317.
Thank you, Chair Scheibel. To testify in opposition on Senate Bill 317, please press *9 now to take your place in the queue. Once again, to testify in opposition on SB 317, please press *9 now to take your place in the queue.
What is our last?
And Chair, at this time, there are no callers to give opposition testimony on SB 317.
Thank you. It looks like we do have somebody on Zoom who wants to give neutral testimony. The Department of Juvenile Justice Services, perhaps? Go ahead.
Good afternoon, Madam Chair, Chair Scheibel, and distinguished members of this committee. My name is Jack Martin. I currently serve as the Director of the Clark County Department of Juvenile Justice Services. We will not be testifying in neutral. I apologize. Our technical difficulties here. We will be testifying in opposition to the bill. Thank you. Thank you to the committee members I work with and the sponsor, Senator Orenshaw, and Mr. McCann and Mr. Richardson. And I'll give you some of the reasons for our opposition. I do agree with Mr. McCann. We agreed on some parts of this, but there's some parts that don't. And if you'll allow me, I'd like to give you a couple of reasons on why we oppose. SBC, a couple of sessions ago, the legislature recognized that in order to protect the children under the care and custody of DJJS or DFS, that employees regularly working with those children needed to be held to a higher standard of conduct. That legislation directed that employees charged with domestic violence, DUI, and other significant criminal acts, not every criminal act. 62G is very specific in the crimes that would disqualify somebody from working within the department. Those acts could not interact with a child or a relative of a child under the department's care while those charges were pending. Prior to that legislation, there were staff working with youth that had pending sexual assault charges, domestic violence charges, and other criminal charges listed in NRS 62G. SB 317 continues the existing statutory language prohibiting the employee from working with the child while those charges are pending. However, it adds a new provision that if the employee is ultimately not convicted of the charge that resulted in their leave of absence, that the county would be liable for all back pay for the time that employee was off work. Clark County has no control over a staff being arrested for a crime listed under the statute. County has no control over what the charges the district attorney may file against that employee. The county does not control the filing date to start the court process. It does not control the setting of future court dates, postponements, plea deals, counseling order dismissals, or a reduction to a crime not covered by the statute. The county has no control over whether the victim of a crime will even show up at a hearing. In fact, it has been estimated that almost 35% of domestic violence cases have to be dismissed simply because the victim does not show up at a trial, not because the event did not happen. It is therefore simply unfair to hold the county responsible for back pay when the statute requires the county to put an employee on leave and the county has no control or even any influence on what happens in the case after it is filed. DUI and DUI charges are often reduced to reckless driving. Staff have negotiated to use their accrued time during the correction period. Adding this language to statute is solving a problem that does not exist. This bill will allow staff to go through a court process that could extend over a year and a half at the taxpayer's expense. DJJS peace officers and other DJJS employees should be held to a higher standard due to their ability to remove the freedoms and liberties of our youth. Staff provide services to the families for similar issues. DJJS should be held to a higher standard. And just as a side note, these are very specific charges. We're talking about 7 charges. We're not talking about any charge. And because a charge is dismissed, does not equate to that event not occurring. So I want to be very careful how we talk about dismissals does not mean officer conduct. And in light of our current, how we're viewed in the community, how officers are now fighting for what we've seen, I'm very trepidatious as a law enforcement officer to seek, lessening the charge against our standards of conduct. We should be held to a higher standard than the children in which we supervise, not a lesser standard. Thank you for allowing me to testify, Madam Chair. If we have any questions, myself or Assistant Director Wheelahan are available to answer any questions at your leisure.
Thank you so much. And if the record could please reflect that testimony was given in opposition to the bill. Do the members have any questions? All right, I don't see any questions, so we appreciate everybody's input. At this time, I will close the hearing on SB 317. I believe we have everybody present, so we can move to our work session. And I'm just taking a look at who we have. Let's start with SB 356. Mr. Guinan.
Thank you, Chair Scheibel. This is Patrick Guyan, Committee Policy Analyst. As the chair just mentioned, we're going to start with Senate Bill 356 in our work session today. This is a committee bill sponsored on behalf of the Interim Child Welfare and Juvenile Justice Committee. The committee just heard the bill a couple days ago, so I'll try to be quick. Senate Bill 356 requires the Nevada Department of Corrections and the Division of Child and Family Services, in consultation with the Juvenile Justice Oversight Commission and other stakeholders, to study the feasibility of housing youthful offenders regionally in DCFS facilities or in county facilities, and to look at developing a new model for housing youthful offenders in which those between 18 and 24 years of age who've been convicted as adults and who will be released from confinement before reaching 25 years of age would be housed separately from offenders who will not be released before they reach 25. The bill enumerates the issues to be addressed in the study, including costs for facility upgrades, construction, complexities of utilizing memorandums of understanding between agencies regarding staff and other issues, cost savings and budgetary matters, and necessary statutory changes that would need to be made to implement this program, and other matters deemed pertinent by the agencies. And it directs the DOC and DCFS to submit a report of the findings of the study to the Child Welfare and Juvenile Justice Committee no later than July 1 of 2022. There are no amendments, Chair Scheibel.
Thank you, Mr. Guinan. Are there any questions from members of the committee? Senator Settlemyer, is that a question?
Do pass.
A motion to do pass. Is there a second?
Second.
A second from Senator Hansen. Any discussion on the motion? Seeing none, we will go to a roll call vote, please.
Vice Chair Canizaro,
Yes.
Senator Orenshaw,
Yes.
Senator Harris,
Yes.
Senator Settlemyer,
Yes, sorry.
Senator Hansen,
Yes.
Senator Pickard,
Yes.
Chair Scheibel.
Yes, thank you. With that, the motion carries. Do pass SB 356. Senator Orenshaw, would you like the floor statement?
Yes, thank you,
All
Chair.
right, it is yours. We will close the work session on SB 356. We will open the work session on SB 357. Mr. Guinan.
Thanks, Chair. Again, Patrick Guyan for the record, Committee Policy Analyst. SB 357 is another bill on behalf of the Child Welfare and Juvenile Justice Committee that we heard on April 6th. This is part of the package. SB 357 requires the Department of Corrections to establish a system to track expenses directly related to housing youthful offenders who are under 18 years of age. I don't know if I need to go through which expenses are going to be tracked, Madam Chair. There are no amendments, and that's all I have.
Let's just see if the members have any questions that they failed to ask 2 days ago when we heard the bill. Sorry. If you do have questions, you're welcome to ask them. Senator Settlemyer has moved to do pass the bill. Is there a second?
Second.
There are lots of seconds. I will give this one to Senator Hansen. And with that, is there any discussion on the motion? Seeing none, we will take a roll call vote, please.
Vice Chair Canizaro,
Yes.
Senator Orenshaw,
Yes.
Senator Harris,
Yes.
Senator Settlemyer,
Yes.
Senator Hansen,
Yes.
Senator Pickard,
Yes.
Chair Scheibel.
Yes. And with that, the motion carries. Do pass SB 357. Is there a volunteer to take the floor statement? Senator Orenshaw. Okay, I wasn't sure if you would want all of them, so I will give this one to you as well.
Thank you, Chair.
And we will now close the work session on SB 357 and go to a work session on SB 365. Mr. Guinan.
Thanks, Chair Scheibel. Patrick Guyan for the record again. Another Child Welfare and Juvenile Justice Committee bill that this committee carried. SB 365 requires the Department of Corrections and the Division of Child Family Services to develop and implement a pilot program, whereby youthful offenders under 18 years of age who have been tried and convicted as adults may be housed in the custody of DCFS rather than in an adult NDOC facility. Agencies must implement the pilot program no later than January 1 of 2022 and report on its status, including recommendations for legislation, by the following year, January 1 of 2023. That's all, Madam Chair. There are no amendments.
All right. Any questions on this bill? Any motions on this bill?
Move to pass.
We have a motion to do pass from Senator Pickard.
Second.
We have a second from Senator Harris. Any discussion on the motion? Seeing none, we will go to a roll call vote, please.
Vice Chair Canizaro?
Yes.
Senator Orenshaw?
Yes.
Senator Harris?
Yes.
Senator Settlemyre?
Yes.
Senator Hansen?
Yes.
Senator Pickard?
Yes.
Chair Scheibel?
Yes, thank you. With that, the motion carries to pass on SB 365, and I will assign this floor statement to Senator Orenshaw.
Here.
With that, we will move next to our work session on SB 187. Mr. Guinan, are you ready to walk us through the work session document?
I am. Excuse me, I am, Chair Scheibel.
Thanks.
Patrick Guinan for the record. We're on Senate Bill 187 now. This relates to solitary confinement of offenders. The bill was sponsored by Senator Spearman, who was just highlighted on my screen, so I know she's here today to answer questions if the committee has any. Senate Bill 187 requires the Director of Nevada's Department of Corrections to adopt regulations governing the use of solitary confinement, to provide that solitary confinement may only be used as a last resort in the least restrictive manner and for the shortest period of time safely possible, limit the use of disciplinary segregation to specific circumstances, review and evaluate the use of solitary confinement, to provide offenders assigned to solitary confinement with programming, to require training for staff who work in solitary confinement units, and to establish minimum requirements, reviews, and other procedures relating to various types of solitary confinement. DOC is to report annually to the Advisory Commission on the Administration of Justice information on the use of solitary confinement, including the number of offenders assigned and for how long, whether any of the assigned offenders suffer from mental illness, demographic information on assigned offenders, related disciplinary hearings and reviews of the assignment of vulnerable offenders, and on programming provided to assigned offenders. The bill also removes several provisions regarding the length of stay in solitary confinement and instead limits the length of that time that any offender may be placed in disciplinary segregation, 30 days. There are no amendments. That's all I have, Chair Scheibel.
Thank you. It looks like we already have one question from Senator Pickard. Go ahead.
Thank you. Just a quick question. Senator Spearman, does this report include those that are put in segregation or solitary confinement, not for disciplinary reasons, but for some administrative reason? Maybe they were in need of protection, but they end up in a solitary situation. Is the intent to include those as well?
Oh, thank you, Madam Chair. I have Nick from ACLU is on, and he's on to answer questions just like this. Okay.
Hello, thank you. Nick Shepak for the record from the ACLU. Through you, Chair to Senator Pickard. Yes, the intent is to capture anyone who's held in solitary confinement, but to delineate the reason for such so that we can get a full picture of who is in solitary and for how long.
Thank you very much.
All right. I don't see any other questions. Is there a motion to do pass?
We'll move, Chair.
There's a motion from Senator Orenshaw. Is there a second?
Second.
There is a second from Senator Pickard. Any discussion on the motion? Not seeing any, we will go to a roll call vote, please.
Vice Chair Canizaro?
Yes.
Senator Orenshaw?
Yes.
Senator Harris?
Yes.
Senator Settlemyre?
Yes.
Senator Hansen?
Yes.
Senator Pickard?
Yes.
Chair Scheibel?
Yes. And with that, the motion carries. Do pass on SB 187. Senator Spearman, would you please take the floor statement? Thank you.
Yes, I will.
That closes our work session on SB 187. We will now open the work session on SB 267.
Thanks, Chair. Again, for the record, Patrick Magnan. We're now on Senate Bill 267, which establishes provisions relating to the collection and reporting of information concerning diversity and equality in the workplace. The committee just heard this bill on April 6th. It's sponsored by Senator Spearman. And SB 267 establishes an annual workplace diversity and equality survey of businesses in Nevada that employ 500 or more people. Department of Taxation is to develop the survey in consultation with the Nevada Commission for Women and the Nevada Commission on Minority Affairs, and is to gather information on females and persons from underrepresented communities. The committee will remember that at the initial hearing on the bill, Senator Spearman proposed a conceptual amendment with former Senator Harris, and the committee discussed that proposed amendment at length. It has been revised a little further and is attached in full here. And I can go through it point by point, Chair Scheibel, if you'd like, or I don't know if Senator Spearman would prefer to discuss it, but either way, I'm happy to do it if you just let me know what you prefer.
If you would go through it for us, Mr. Guinan.
Sure. All right. So, number one, the amendment creates a voluntary reporting program for corporations of all sizes. Specifically, the proposed amendment would change the requirement that only corporations which employ 500 or more employees must complete the report to an authorization for corporations of any size to voluntarily complete the report, and authorize rather than require a corporation that has an internet website to make its reports available on the website. And third, make any other corresponding changes regarding the reporting. Number two, it would expand the applicability of the bill so that in addition to corporations, the provisions of the bill would also apply to state governmental agencies, including without limitation, the Nevada System of Higher Education and all the institutions of NSHE, and 2 local governmental agencies. However, unlike corporations, the proposed amendment would require such governmental agencies to complete the report. Third, it would provide that corporations would submit their completed reports to the Department of Taxation and require local governmental agencies to submit their completed reports to the department. The report prepared by the Department of Taxation would include only information regarding corporations and local government entities. Fourth, it would require state governmental agencies to submit their completed reports to the Division of Human Resource Management of the Department of Administration instead of the Department of Taxation. The division would be required to make available on its website the annual reports submitted by state governmental agencies with personally identifiable information redacted. And second, it would aggregate the data relating to the annual reports with personally identifiable information redacted. The division would also be required to complete annually the information contained in the reports submitted to the division into one report and submit that to the governor and the director of the Legislative Council Bureau. Fifth, as suggested by Senator Settlemyer during the initial hearing on the bill, it would require the Department of Taxation to include questions in the survey which request first the number and types of vacancies at a corporation or agency, and second, the rate of attrition at the corporation or agency. Sixth, it deletes provisions of the bill that impose penalties, including penalties for perjury, since the program will be voluntary for corporations. And lastly, it deletes Section 6 sub 3, Section 11, and Section 12 of the bill, which require the Department of Taxation to consult with the Nevada Commission for Women and the Nevada Commission on Minority Affairs when developing the survey. And second, would require both the commissions to assist the department in developing the survey. It would instead provide that the department must develop the survey in consultation with the Legislative Commission. And that is the entirety of the amendment, Chair Scheibel. I have nothing further.
Thank you for an excellent summary. Are there any questions from members of the committee about this bill? All right. Is there...
Madam Chair, I'm sorry, I just wanted to make this note. Senator Settlemyer suggested something yesterday, and that his suggestion is also in the amendment.
Thank you so much. I believe that is the portion about attrition and or turnover rates. Great. Is there a motion on the bill to amend and do pass?
So moved.
We have a motion from Senator Orenshaw. Is there a second?
Second.
A second from Senator Harris. Any discussion on the motion? Senator Hansen.
Thank you, Madam Chair. I'm a strong no on this. I think this is Big Brother on steroids. We're asking highly invasive and very, very personal questions of people who we should not be bothering. If they want to do some very generic questioning, but when you look at the in-depth questioning that this bill talks about, everybody's sex life, everybody's racial composition, I think we've gone way, way overboard in this whole idea. I think something like this could actually be handled through a private sector hiring process where they can find out and do a survey to see where some of these things are. But for the government to force this on the private sector is outrageous and wrong, and I'm a strong no.
All right, any other discussion? Okay, we will move to a roll call vote on the motion on the floor, which is to amend and do pass SB 267.
Vice Chair Cannizzaro.
Yes.
Senator Orenshall.
Yes.
Senator Harris.
Yes.
Senator Settlemyre.
Yes.
Senator Hansen.
No.
Senator Pickard.
That was a yes, sorry.
Chair Scheibel.
Yes. With that, the motion passes to amend and do pass SB 267. Senator Spearman, would you take the floor statement, please?
Absolutely.
Thank you so much. And thank you for joining us for this work session. We are now closing the work session on 267. We will open up a work session on SB 177. Mr. Guinan, would you please lead us through the work session document?
Thanks, Chair Scheibel. I'd be happy to. Again, Pat Guinan for the record. This is Senate Bill 177, which is sponsored by Senators Brady, Cannizzaro, and Scheibel, and it revises provisions relating to the account for aid for victims of domestic violence. We heard it on March 16th. SB 177 revises the eligibility of nonprofit organizations that provide services for victims of domestic violence to receive grants from the account for aid for victims of domestic violence. It also renames that as the account for aid for victims of domestic or sexual violence. The bill requires that an organization must provide services exclusively to victims of domestic violence in a county with a population of 100,000 or more, but need only provide services primarily to victims of domestic violence in a county with a population of less than 100,000. It also excludes nonprofits that provide services exclusively to victims of domestic violence from the requirement that they be able to shelter victims on any day, at any hour, and be able to store and prepare food in order to receive grants. The administrator of the Division of Child and Family Services must allocate 75% of the money allocated to a county under this program for services for victims of domestic violence and 25% to services for victims of sexual violence. The number of grants that may be awarded in counties with populations of either less than or more than 100,000 is limited, and the bill eliminates the requirement that 15% of all money allocated from the account to a county whose population is 700,000 or more must go to an organization specifically created to assist victims of sexual assault. A portion of the fee that's collected by a county clerk when issuing a marriage license that is used to fund the account is raised in this bill from $25 to $50. There are no amendments, Chair Scheibel, and that's all I have.
Thank you, Mr. Guinan. Are there any questions from members of the committee on SB 177? Senator Hansen.
No questions, but a comment. Madam Chair, you actually challenged some of us, if you'll recall, to look for some empirical data on whether or not being married has is actually an advantage and reduces the amount of domestic violence. So I answered your challenge, and I just real quickly, a couple of studies. There are actually dozens and dozens of them. Most of them, frankly, have very small sample sizes. So I found two with the largest. The first one had 19,517 people. Real quick, it's by the Biomedical Center for Public Health. Intimate partner violence. Here was their real quick what they said. Despite wide variations in the prevalence of intimate partner violence, many factors affected risk similarly across sites. Secondary education and formal marriage offered protection, while alcohol abuse and cohabitation increase the risk. And the other one real quick, this is from the Journal of Criminology, 3,716 participants. And they just said, this study examines the prevalence of abuse reported by married and dating participants. Then the conclusion was, when comparing violence in both relational contexts, we found that in terms of perpetuation, more dating partners reported physical abuse and severe forms of physical abuse than married partners. So just want to get that out there, because this bill, if we pass this tax, according to the people that are involved in this industry, as the tax rate goes up, the number of people getting married goes down. If our goal here is to reduce domestic violence, we should be encouraging marriage. So just thank you for that, Madam Chair. So I did answer your challenge, though.
All right. I see Senator Picker's hand is also up.
Thank you, Madam Chair. It's a weak act to follow that one, but I also reached out to some individuals that represent the marriage industry. They've been saying that we've been losing ground to other marriage destinations for decades, and they expressed some really serious concerns about what this would do to those marginal questions. People who can afford to travel to a destination for marriage generally can travel pretty much anywhere they want within some reason, and they're exceptionally concerned that because they're not directly associated with this, they shouldn't be the ones shouldering the bulk of the burden. So I would encourage the sponsor of the bill to look for a permanent funding source outside of marriage, but I cannot support this bill, even though I certainly sympathize with the need to expand the services. Thank you.
All right, and Senator Settlemyre.
Thank you, Chair. I appreciate it. I talked to the sponsor about letting to find another way to fund this. I absolutely agree with the bill, with the concept. And if we want to just make this a line item appropriation out of the budget, I'm sure you can have this bill out of here unanimous without a problem. Continuing to apply it to a fee that has a marginal nexus at best is our objection. It's not to funding such a worthy endeavor. And I wish that we could put that amendment forth and have a bipartisan agreement to put more funds to this worthy cause. But for now, I have to oppose. Thank you.
All right. Any other? Go ahead, Senator Cannizzaro.
Thank you, Chair Scheibel. And I just wanted to again thank Senator Ratty for bringing this forward. Obviously, you know, when we are talking about domestic violence and sexual violence, so much of that is part of power and control. And I think the more tied you are to a partner, certainly it has been my anecdotal experience that it is that much harder to leave that individual. And so I don't think that this is necessarily a piece of, there is less likely to be the financial ability to leave or the support system that exists outside of the home for that person to leave and to be comfortable and to be able to take care of themselves. And so I think certainly the policy here is not about correlation, but rather this is currently how we fund these types of services. And it is woefully inadequate for what we have done. And I think Senator Ratty did a great job during the hearing of presenting the data that this has remained unchanged for a substantial period of time. And yet we know that there are so many more resources that are needed. I think everyone in this committee is in agreement that this is something we should fund. The argument about finding stable funding sources and permanent funding sources or allocating other things or looking for another place to find this, I think unfortunately this is where we find ourselves in a lot of these instances, is how we fund things in this state is by finding something to charge a fee to, and that is how we have continued to operate. And so, you know, without some grander plan and the support behind it to figure out what that other permanent funding source is, I think that this is a very small burden to ask in order to fund what are very legitimately needed services here in the state. So I'm going to be supporting
Thank you, Vice Chair Canizaro. Anybody else have questions or remarks? If not, I'll take a personal point of privilege to indicate my support also for SB 177, and I agree with the majority leader. I also am disappointed to hear different reasons not to support a bill that people purport to support in theory to fund fighting domestic and sexual violence. To me, the correlation isn't even important. If there were another tax we could levy, another fee we could impose to raise this money, it could be on candy bars or bubble gum. This money is desperately needed in our state. And I don't know, maybe you guys do, but I don't know any married person who would want their refund back, knowing that part of their license fee went to helping combat domestic and sexual violence. And so I am happy to support this bill. As Senator Ratty very eloquently pointed out in the presentation, for 40 years, we haven't found another solution. So I'm ready to support SB 177 and make just this most incremental increase to the funding for the one funding source we have to fight sexual and domestic violence here in the state of Nevada. Senator Orenshaw.
Thank you, Chair Scheibel, and I'll be brief. I just, I was pretty moved at the hearing by the coalition Senator Ratty had brought together, and seeing, or hearing former Lieutenant Governor Wagner talk about the original effort to try to get this on the books back in the early 1980s, and how bipartisan it was there. And I hope that we will kind of achieve that perhaps on the floor, even if not today, but I'll be supporting it.
All right, and at this time, I will accept a motion to do pass.
So moved, Chair Scheibel.
There is a motion from Senator Harris. Is there a second?
Second.
There is a second from Senator Orenshaw. Any discussion on the motion?
Madam Chair.
Go ahead, Senator Settlemyre.
Thank you, Chair. In that respect, like I indicated, I think this is worthy and we should fund it. Let's do it right now. American Recovery Act. We know it's going to pass. When it does, let's dedicate $10 million to this, or $20 million, or whatever you think is the appropriate amount to help these individuals out. I do not support the concept of the nexus that we put in the law a long time ago. I think there are better ways to fund this. It's not an objection to the funding. It's where the funds are coming from. And I will be opposing it based on that.
Senator Ratty, would you like to respond? I would like to hear your response if you're willing.
I appreciate it. I know we're not relitigating the bill here at the work session, but I appreciate the opportunity. So first of all, I spent an awful lot of time and shared along the way with Senator Settlemyre looking at divorce fees, because I think several of the committee members had asked for us to do that. And the good news, unfortunate for us, but good for the state of Nevada, is there's significantly less divorces than there are marriages, and that we would have had to create the divorce fee up to $200. Which seemed inappropriate. And there are actually people who can't afford to get divorced, so that seemed not to be a good solution. And so we sort of set that aside. Nobody approached me with an amendment to the bill, I will say, and so if we had had time to consider an amendment to the bill, I would have definitely taken a look at an amendment to the bill. Here's my concern. Last session, I did a bill on vaping, and we actually raised the tax on vaping and brought into the state about $9 million. And on that bill, we put an appropriation. And that appropriation was for something that I think everybody in this body felt was very important. It was for vaping prevention. Strong nexus, but it was a general fund allocation, and it was an appropriation on a bill. Now we're in a recession, and that money for vaping has been cut 100% because of the 12% cuts that were up. So my lesson is that by just doing a single general fund appropriation, you're good for 2 years, but you are not guaranteed sustainable funding. My concern with the American Recovery Act, which I'm very excited about, is that the vast majority of that is going to be one-shot money. And so we can take a good chunk of money, and if we want to give $10 million to domestic violence and sexual violence out of the American Recovery Act, I will be a strong yes, but it will be appropriate for perhaps building a shelter, but it will not be sustainable long-term funding. the marriage license fee has been sustainable long-term funding for 40 years. So I'm 100% willing to continue this conversation, and will continue to do so in good faith with my colleagues to find a way that we get the funding that we need for domestic violence and sexual violence. But one of the things that I think is critically important is that it is funding that those nonprofit agencies that are critical, essential providers in our state infrastructure for these victim survivors have reliable, sustainable ongoing funding. So let's continue the conversation. I look forward to working with my colleagues to find the bipartisan solution. Thank you.
Thank you, Senator Ratty. I see Senator Hansen has also raised his hand. You may go ahead.
Thank you, Chair Scheibel. Actually, Senator Ratty had thrown out a challenge as well on possible funding mechanisms. So while doing some homework on the bill, I discovered that approximately 80% of the licenses that are sold in Clark County are from out-of-state people who come to Las Vegas for basically a marriage and a honeymoon. So the logical spot to go would actually be a room tax. Now, I recognize that the legislature in its wisdom came up with a big room tax to pay off a $750 million debt on a football stadium for a billionaire, but somehow we're uncomfortable raising the room tax for domestic violence issues. So I sometimes wonder about our priorities when it comes to supposedly worrying so much about domestic violence issues or autism or all the senior citizens issues that are we starve basically, while we're willing to throw hundreds of millions of tax dollars to a football stadium. So I can't help but say, be careful who's pointing fingers about who's crying crocodile tears and who's not. And by the way, I aggressively oppose that football stadium, at least partially because there's a lot of other needs for the money besides a football stadium. So I just want to get that on the record, Madam Chair. And I'd also say in this entire session, we've been aware of the fact that we lost at least $4 billion in fraud because of the failure of us to take care of the Dieter situation. And I haven't seen a single bill in this entire session dealing with some type of a clawback provision where we got the Attorney General or whoever to go aggressively after $4 billion. And let me tell you, that would fund a whole lot of domestic violence issues. So I think we need to start looking at some sources and also where our real true priorities are in the state. Do we really care that much about domestic violence and kids with autism, or do we care about helping billionaires? Thank you, Madam Chair.
All right. For the committee's edification, we have heard several Dieter bills in commerce and labor addressing fraud and other issues that they're facing. And yet here we are today discussing SB 177. There is a motion on the floor to do pass, and we will now go to a roll call vote.
Vice Chair Canizaro?
Yes.
Senator Orenshaw?
Yes.
Senator Harris?
Yes.
Senator Settlemyre?
No.
Senator Hansen?
No.
Senator Pickard?
No.
Chair Scheibel?
Yes. With that, the motion passes to do pass SB 177. Senator Ratty, would you take the floor statement?
I would be honored. Thank you.
All right, that concludes our work session on SB 177. We still have 2 more bills to go. We will move to our work session on SB 369.
Thanks, Chair Scheibel. This is Patrick Guinan. Again, for the record, we're now on Senate Bill 369, as you just mentioned. Senate Bill 369 was carried by this committee on behalf of the interim pretrial release study. SB 369 revises statutes regarding the imposition of bail to comport with the Nevada Constitution. The bill removes provisions requiring an arrested person to show good cause in order to be released without bail. Additionally, the bill consolidates existing procedures for releasing a person with or without bail into a standard procedure for courts to follow in making pretrial custody determinations. It requires a prosecuting attorney who requests bail to prove by clear and convincing evidence why it is necessary to protect the community and ensure the accused will appear in court. And it requires a court to consider the prosecutor's request before imposing bail or any other condition of release on a person. Regarding amendments, Senator Harris, who presented the bill, has presented or offered a conceptual amendment that is attached on the following pages. The amendment revises language in section 3 to authorize a prosecuting attorney to request bail or another condition of release or both. If requesting bail, the prosecutor must prove by clear and convincing evidence why bail is necessary. Court is required, after considering a prosecutor, to only impose bail or a condition of release or both, as the court deems to be the least restrictive means necessary to protect the safety of the community and ensure the person will appear in court. And the amendment also provides that if a person used a firearm in committing the act for which the person was arrested, there is a rebuttable presumption that the least restrictive means necessary to secure the community's safety and ensure the person will appear includes the imposition of bail or a condition of release or both. And that's all I have, Chair Scheibel.
Okay, any questions on SB 369? Okay, is there a motion to amend and do pass?
So moved.
A motion from Senator Orenshaw. Is there a second? Second from Senator Hansen. And I'm going to go next to discussion on the motion, which it looks like Senator Settlemyre would like to start us off with.
And we're dealing with Senate Bill 361, Chair, and there was some testimony, though, that indicated this could actually potentially lead to criminals being let out who would further harm victims of sexual assault. Has that issue been dealt with from the opposition, or is that still out there?
So I think that issue is a broader concern about our bail system and the Valdez-Jimenez decision, which this codifies, which is to say that there is nothing in Nevada law that prevents a judge from allowing a defendant who's accused of sexual assault from being released either on bail or with non-monetary conditions placed on them. And this bill does not change that, but it does not weaken that in any way either.
Okay, appreciate that, Chair. For now, I'm going to oppose it based on the fact I want to try to get that cleared up with the person, look up who opposed that and said that and try to figure that out. Thank you.
All right. Any other questions? Senator Hansen.
Thanks, Madam Chair. I might be a little confused. Is this the bill dealing where if they're in there for 7 days that they automatically have an opportunity to get out? I'm mixing this one up with another one. I'm sorry, we're kind of going through them in a hurry.
Yeah, that's okay. And I think you are mixing it up with another one. SB 369 I presented earlier this week or maybe last week. And this is the one that says that the burden is on the prosecutor to show by clear and convincing evidence that the person poses a risk to the community and or a flight risk in order for the judge to make a determination. And then the judge makes a determination as to what the least restrictive means are to ensure that person's return to court and the safety of the community. The amendment also clarifies that a judge can make that determination without hearing from a prosecutor, because it is common practice for law enforcement agencies to submit an arrest report or an arrest packet directly to the judge without having an in-person hearing. And so we want the judge still to be able to read the report and set bail on Friday night, even though the arraignment might not be till Tuesday morning.
Okay, well, I'm still going to support the measure, but I would like to withdraw my second at this point.
Okay, then would somebody else like to second the motion?
I will second Senator Scheibel, Chair Scheibel.
Thank you, Senator Harris and Vice Chair Cannizzaro. Go ahead.
Thank you, Chair Scheibel. And I wanted to thank Senator Harris for working so diligently on an amendment here that I think does clarify some of my concerns with language here. I think I still have we may still have to have some conversations and potentially a little bit of clarification over the court's ability to set bail and some of the wording in Section 3 to make sure it's capturing what it needs to capture. But I think for today, I feel comfortable voting to amend and do pass because, again, this is more or less codifying with some additional considerations for instances where firearm in the commission of an offense, which I appreciate because I do think that does speak to the safety of the community. And so I'm thankful for that inclusion as well. But the Supreme Court recently ruled in the Valdez-Jimenez case that these are the standards under the Constitution by which we have to, when considering whether to release someone with bail, without bail, with conditions of release, must be considered. And so I feel comfortable that this is the current status of the law, but want to make sure that the language is where it needs to be, but we'll support today out of committee.
And Chair Scheibel, if I may, to Vice Chair Canizaro, it is the intent of the amendment to clarify that the court does have the ability to put forward what they deem is the least restrictive means. And so I'm more than happy to continue to work to tighten that up.
All right, Senator Orenshaw.
Thank you, Chair Scheibel. I just want to compliment Senator Harris for all her hard work during the interim and your work, Chair Scheibel, on the that interim committee on pretrial release and detention, and bringing this bill and the other bills forward. Certainly, there is a national movement towards bail reform. The Uniform Law Commission has promulgated a Uniform Act at this issue, and this is something that's happening in Nevada and around the country, and I will be supporting this legislation.
Thank you, Senator Orenshaw. Senator Pickard.
Thank you, Madam Chair. And I was actually going to just mention the Uniform Act as well. This actually deviates from that a little bit. And it was my understanding after talking to a few prosecutors that the least restrictive means is already the state of the law. Whether or not it's in statute, I couldn't tell you. This isn't my area. But I'll be supporting the bill out of committee, but I'm going to reserve my right. Thank you.
And to clarify, yes, the least restrictive means is currently the state of the law. All right, with that, I think we had a motion on the floor to amend and do pass from Senator Harris, newly seconded by Senator Orenshaw, and now we will go to roll call vote.
Vice Chair Canizaro?
Yes.
Senator Orenshaw?
Yes.
Senator Harris?
Yes.
Senator Settlemyre?
No, with reservations.
Senator Hansen?
Yes.
Senator Pickard?
Yes.
Chair Scheibel?
Yes. With that, the motion to amend and do pass SB 369 carries, and I will assign the floor statement to myself. And that concludes our work session on SB 369. We got one more work session to go. We can do it, guys. Opening up SB 401, Mr. Guinan.
Thanks, Chair Scheibel. Again, for the record, Patrick Guinan. We're now on SB 401, which is a committee bill, again, on behalf of the pretrial release study from the interim. We heard it on April 1st. SB 401 provides for the collection and reporting of data from the court system related to pretrial detention in criminal cases. The bill requires data concerning charged offense, whether bail was granted, denied, or the defendant released without bail, bail amount and conditions of release, the date of initial custody and the date a court set bail or denied bail, the date a defendant was released from custody with or without bail, whether a bail hearing was held, whether a defendant failed to appear, was arrested for violating a condition of release, or was arrested for a new offense while released on bail, and what the sentence imposed, date taken into custody to serve a sentence, and release date are. County and city jails are to notify the appropriate court if a defendant is in custody for more than 7 days after bail is set, if the amount of bail is $2,500 or less. Reports containing this information are to be submitted to the Advisory Commission on the Administration of Justice or the legislature as appropriate and made publicly available on the website of the Administrative Office of the Courts. There is one minor amendment that was requested by the Department of Sentencing Policy. They asked to be added to the distribution list for the pretrial detention report. And that amendment request is attached. And Senator Harris indicated her support for the amendment. That's all I have, Chair Scheibel.
Thank you. I already see hands going up. Senator Hansen, do you have a question on the bill or comment? Go ahead.
Just a quick comment. This was the one I thought that I was helping with at the last time thing. So I'm in favor of the bill, Madam Chair. Just wanted to get that cleared up on that second. I apologize for my mistake.
No problem. And I wanted to clarify with you, Senator Harris, I am looking at the language of the bill and the amendment, and it does require that the local detention center inform the court that somebody has been held for more than 7 days with bail of less than $2,500, but it does not indicate anything about what that means the court should or must do about it.
Thank you for the question, Chair Scheibel. That is correct.
All right, anybody else? Otherwise, I will accept a motion to amend and do pass.
Move, Chair.
We have a motion from Senator Orenshaw, and we will take Senator Hansen's second on this one. Senator Pickard, I wouldn't take that away from Senator Hansen after all he's been through. And is there any discussion on the motion? All right, then we will go to our last roll call vote of the day on a motion to amend and do pass SB 401.
Vice Chair Canizaro?
Yes.
Senator Orenshaw?
Yes.
Senator Harris?
Yes.
Senator Settlemyre?
Yes.
Senator Hansen?
Yes.
Senator Pickard?
Yes.
Chair Scheibel?
Yes. And with that, the motion carries to amend and do pass SB 401. Senator Harris, would you like to take the floor statement?
I will, thank you.
All right, the floor statement is yours. And that concludes our work session for today. And Senator Pickard has something to say.
I just was wondering, Madam Chair, if the intent was to skip over 359. We've been bouncing around and I didn't see that. I just wanted to make sure I didn't miss something.
Yes, and I appreciate you catching that. We are going to push SB 359 to tomorrow's work session.
Thank you.
Sure. And with that, we will move on to our next hearing of the day, SB 261, from a member of our committee and one of our colleagues, Senator Settlemyre. Please go ahead whenever you're ready.
Thank you, Chair. I appreciate the concept to present Senate Bill 361. This is Senator Settlemyre representing Senate District 17. The bill relates to consumer debt. Sometimes in these situations, we have individual claims that are so small for consumer debt that the concept of going after them is problematic in the realm that it costs far more money than to collect. And then sometimes individuals continue to do that. So the concept of the bill would be to put in a clause that the minimum fee for the attorney fee would be $500 in order to try to facilitate the collection of those types of debts. With that, if acceptable, though, I would allow Neil Tomlinson is here to present on the bill at this time.
Yes.
Are you okay with that, Chair?
Go ahead.
Okay.
Yes.
Thank you, and good afternoon. Thank you, Chair Scheibel and Vice Chair Canizaro, members of the committee. For the record, I am Neil Tomlinson, N-E-A-L, last name T-O-M-L-I-N-S-O-N, from the law firm Brownstein Hyatt Barber Schreck. I'm here today representing the Nevada Collectors Association. I want to start by thanking Senator Settlemyre for bringing this bill forward. The bill before you today is straightforward. I'd like to start with a little background as to why it's needed. Last session, AB 477 contained a provision which affected the calculation of attorney's fees in actions relating to the collection of consumer debt. That provision provided that attorney's fees could not exceed 15% of the original consumer debt when a percentage was specifically stated in a consumer form contract. And alternatively, when a percentage was not stated in a consumer form contract, the attorney's fees are capped at the lesser of either 15% or fees calculated as a reasonable rate for a reasonable amount of time to obtain the judgment. We believe there was an unintended consequence by capping the attorney's fees at 15% because it's having a severe negative impact on the small business community when they try to collect on the smaller valid debts. Many small businesses don't know how or don't have the time to navigate small claims court on their own, so they turn to an attorney for assistance. Many of you are lawyers yourselves. You understand the time and effort that it takes to prepare the necessary pleadings, complete the filings, serve the defendant, and appear at court hearings. Depending on the value of the debt, the maximum of 15% attorney's fees creates an artificial threshold when a lawyer decides whether to take on a case. So something lower than that, whatever that threshold is, then the small business owner cannot get legal representation then they're faced with the decision of either attempting to navigate the legal system on their own or just not collecting on the payments that they're rightfully owed. It's inequitable to expect small businesses doing their best to stay open to carry the burden of these valid debts simply because they cannot find legal representation to assist them. So accordingly, SB 261 seeks to allow a minimum level of $500 for attorney's fees in these types of actions. The 15% cap would still be applicable in most instances. However, an attorney would be entitled to at least $500, which is significantly less than any attorney's fees calculated at a reasonable rate or a reasonable amount of time to attain a judgment, even on the simplest cases. So I know he was having some audio difficulty, but I want to turn it over now to Tim Myers, who's the president of the Nevada Collectors Association, and he can kind of give you a specific example and kind of explain to you the issue a little further. So with that, I turn it over to Tim Myers from the Nevada Collectors Association.
Thank you. Thank you, Neil. Thank you for allowing me the opportunity to be in front of you today. My name is Tim Myers, Timmyers. I'm the president of Nevada Collectors Association. Nevada Collectors Association represents on average 30 brick and mortar businesses in the state of Nevada who are all licensed and regulated by the Division of Financial Institutions. I believe in 2019, the provision at issue intended to limit the amount of interest in attorney's fees against a consumer. However, it has had a terrible unintended consequence, as Neil noted. Most licensed agencies are corporations and must retain legal counsel in the state of Nevada. We represent all types of businesses in the state of Nevada, and most businesses expect us to go to court for them. These are the small businesses that can't hire corporate counsel at $300 an hour to represent them on a case-by-case basis. By the way of example, under current law, if a small doctor's office retains one of our members to collect on a valid $1,500 medical bill, the maximum allowable attorney's fee would be $225. Doesn't matter if they settle, default, or goes to trial. That's the max that an attorney can get, or the courts can award. As most of you probably know, we cannot find a lawyer to represent us in cases like this. It simply takes too much time and effort to prepare and serve pleadings, then attend the court hearing. $225 doesn't cover the cost of doing it. Therefore, this bill seeks to correct this unfortunate consequence by allowing a minimum of $500 so the small businesses have the ability to collect on valid bills owed to them. I want to thank you for allowing me to be a part of this. I have been doing this for I've been collecting from my neighbors in Nevada for 35 years, respectfully, and I would like to continue to do so. So thank you, and I'm happy to answer any questions you have.
Okay. Senator Pickard, go ahead with your question.
Thank you, Madam Chair, and thank you all for presenting the bill. I'm the last one who would stand between an attorney and getting paid, given I'm paid by the hour as well. But I'm trying to understand how this works, because in my experience, the collection side of this, usually we would assign the rights to the claim in its entirety in exchange for 50% back, plus or minus. I mean, every situation is a little different, but that's the collectors get a chunk of the amount owed. And I always thought that was to pay the attorneys. So do I understand correctly that this would be an award of attorney's fees in addition to the other collection costs that are accrued and contracted for?
Only if we go to court. So basically, most please. Am I okay to answer?
Yes, you just have to put your name on the record for our transcriptionists and secretaries.
Okay. Tim Myers, and from Nevada Collectors Association. So our collection agencies, most of our members are contingency collection agencies. So anywhere from 10, 15, 25% is what we charge the client, only if we collect. When we advance or go on to proceed to court on a consumer that has the means to pay but refuses to pay, we advanced all court costs and attorney's fees for our client, for the small businesses out there. Then once we go to court, over the years, we have to make sure we have a contract from the original creditor that states that our attorney's fees are awarded or allowed if they default, and then takes attorneys to go to court. So by advancing all court costs and attorney's fees is the addition to the contingency fee that we make. So we ask the courts to return it to us once we go to court, and we have, and then this is just limited down to 15%. So on a $1,000 bill, we're going to get $150 back, and our attorneys probably cost us anywhere between $350 to $400 to have the attorney prepare and file the lawsuit. So it's not feasible for us to go further for our small businesses anymore.
All right, that makes sense. That clears it up, and you're not paying your attorneys enough.
They won't take us anymore.
Okay, is that all? Great, Senator Harris.
Yeah, that's all I have. Thank you.
Thank you, Chair Scheibel. I'm just wondering, do we do this anywhere else in statute where we're kind of setting some guaranteed income for another profession outside of, let's say, where we establish Medicare reimbursement rates or things of that nature? Is this something we do in other places?
Madam Chair, Neil Tomlinson through the chair to Senator Harris. I'm not sure of the answer to that. I know that these fees were already included in the law in the IRS, so this is just kind of a revision because it just wasn't workable for the situations that Mr. Meyer described. So I'm not sure about other situations.
This is Senator Settlemeyer. Senator Harris, we can look up where else the state of Nevada establishes a minimum wage for things and get back to you on that.
All right, if there are no other questions, I have a few. I was wondering, since we are putting an exact dollar amount in here of $500, if you could give us a picture of what these settlements normally look like, either the average claim or the average amount recovered, something useful like that, perhaps?
Myers, Nevada Collectors Association. So we handle claims from $15 to $20,000. Depends on the creditor and who they are. From MD Energy all the way up. Utilities, medical, retail, commercial. So there's a threshold from the industry standards. There's a threshold of what you can afford to sue on, and you don't. So there's you're not going to, coming from a Nevada standpoint, being in Nevada, hiring Nevada people and collecting from my Nevada neighbors, you don't want to take everybody. The last thing we're going to do is go to court. But you have your clients that they can't afford to go out and hire their attorney at $300 an hour. So they hire us to do the collections and then ask us, we advance all the costs and everything to take to court on a mass basis or a volume basis. So we're not going to take a $200 account to court because it's just not feasible for us to spend that much money to go after them and whatnot. So it's hard to say, like right now, looking at the bill the way it was entered in 2019, we'd have to look at suing people for $2,000 to $3,000 in order to be able to pay for the attorney to be able to recover the cost at 15%. So we're leaving out the pool man, the electrician, or the people who are doing the $500, $600, $700 services that we can no longer take to court because we're only going to be awarded less than $150 for attorney's fees. And because by doing the $500, I guess we're trying to include the $500, $600, $700, $800, $1,100 bills in there for the small businesses in there that hire us. Does that answer your question?
I think it is. So, and I'm afraid for the answer to this question, but it sounds like this is specifically targeting a case in which the recovery might only be $200 or $300. You are ensuring that anybody who has a judgment against them for $200 will have to pay at least $500 in attorney's fees in addition to whatever the judgment is against them.
And on a case like that, if our client wanted Tim Myers again, like the Nevada Collectors Association. So yeah, if it was a $200 case, that would be up. It's a minimum of $500, but I believe, if I'm not mistaken, still awarded by the court or the juror sitting on the bench who awards us the attorney's fees. So Neil, I'm not sure the answer to the question that feasibly we wouldn't sue a $200 bill. I'm not sure.
Okay. I just want to, think maybe I'm not understanding this, because let's say that I am the defendant in this suit. I owed $200. If the person I owed it to decided to take me to court for that $200, and this law is in place, and the 15% has to, 15% of $200 would be some $30. So what would the attorney's fees be on that $200 claim under this?
In the past, if we went to court, it would be based on the judge. The judge would award the attorney's fees. So there was never a set amount based on what the judge would award. They would just award attorney's fees.
So now we're putting a floor on the award of $500. So this effectively makes it so that there are no claims that are not worth going after, because where it used to be that an organization wouldn't go after a $200 claim because they knew that they weren't going to get even $200 in attorney's fees. Now I can go after a $3 debt and get a $500 windfall in attorney's fees. Why wouldn't I go collect every single debt that is owed from people who have very, very small outstanding amounts?
Tim Myers again, Nevada Collectors. Going to that, I think 70% or 80% of the people in America will pay anywhere up to a $300 to a $200 bill. If you're not paying a $200 bill, it's, again, it's what we do. We get $3 copays from a medical facility. I can't answer that, but I would not. Our members pretty much have a threshold that they don't really sue anything under $200, $300. They wouldn't do it. So it would be a work court, but I'd be happy to. Neil, I don't know if we can amend it to put no more than $200. I don't know.
Madam Chair, Neil Tomlinson again. Just to add on to what Mr. Myers said, I think this is mainly designed to fix the problem where you've got valid debts between $1,000 and $3,000. That's sort of range. Certainly, these smaller debts. I think what Mr. Myers is saying is that his association members, they don't really go after those small dollar ones in litigation because it's just not worthwhile. But the reality is there's a lot of small doctor's offices and the pool cleaner and the housekeeper and different services that are not getting paid, and they legitimately should get paid. If people have the option to just avoid paying because they know that they don't have to and that they won't go after them, I think that that's not a good situation either. So I think that what this is designed to do is those debts that are large enough to perhaps litigate, but still small enough that there's an incentive to collect on it. That's really what we're trying to fix here, because the 15%, there's obviously no attorney that I'm aware of in the state that would take any smaller case for 15%. And if we're saying that that's the policy of the state, that you can just avoid any small debt, I don't know that that's a good policy. So this is just attempting to fix those claims that Mr. Myers described that are between $1,000 and $3,000, that kind of range, that are can be problematic to collect because they're still significant enough, but you still can't get an attorney to take those.
Okay, I think I'm finally understanding. This might be a question better directed at the sponsor, but basically what you're saying then is that there currently exists these debts. They're between $1,000 and $3,000, and it's not worth the money to go after them for what you're going to recover. So basically we have a market failure that you're asking the government to come in and fix by putting an artificial $500 floor on the amount that the debt collectors can recover in any of these cases, because the free market isn't doing it by itself.
Madam Chair, if I could please, I think with that answer to that question though, you first have to indicate though that we as the government stepped in and interfered with those market forces when we put forth a rule establishing a percentage to begin with. That's my opinion.
Okay, so I'm done with my questions. Senator Harris.
Thank you for the second bite, Chair Scheibel. I don't know who might be best suited to answer this question, but I'm wondering how often are do consumer contracts have provisions that shift the recovery of attorney fees automatically onto the consumer if they have to go and collect the debt at some later point? Do we know if contracts tend to contain these provisions? Is that rare? Do you have any insight at all?
Madam Chair.
This is Senator Settlemyer, and I'll try to look that up and get back to you. I'm not aware enough in the field to know that. One of these gentlemen may have more information or what's more customary also is occurring throughout the industry in other states. I'll let one of them try to address it.
Tim Myers, Nevada Collectors Association. Most of our clients all have a provision in a financial agreement with their consumers or with their credit, a consumer creditor that allows for if it goes past debt or if it goes to accounts receivables, that they'll be responsible for the court costs and insurance fees. There are utilities or other creditors out there that don't utilize a contract. So like for instance, on a utility, the Public Utilities Commission does allow for attorney's fees and court costs if they go delinquent. Other hospitals, same thing, financial, they have a financial agreement. Mostly on, when it comes to medical, it's mostly not everybody wants to go to the doctor or hospital, but there are dermatologists and other ones where they do go and do services that require, and so they do have detailed financial agreements that allow for court costs and insurance fees. Most commercial businesses, landlord leases, they have provisions that if you default, you're going to be responsible for court costs and insurance fees. So we're entitled to ask for it, but when 2019, when they entered the AB 477, it capped the attorney fees we can get for the smaller businesses at 15% of whatever the debt was. So we can go to court, we can retain and ask for the court costs and attorney fees, but now we're capped at 15%.
And so, Mr. Myers, if I just want to make sure I'm summarizing your answer correctly, what I'm hearing you say is in some industries, it is fairly common to have in the financial agreement that the person would be responsible for the attorney fees and costs, although those are currently capped at 15%.
Right.
Thank you.
All right. Any further questions on SB 261? I don't see any more questions. We will take testimony in support of SB 261.
Thank you, Chair Scheibel. To testify in support on Senate Bill 261, please press star 9 now to take your place in the queue. Once again, to testify in support on Senate Bill 261, please press star 9 now to take your place in the queue. Caller with the last 3 digits, 892, please slowly state and spell your name for the record. You will have 2 minutes to speak and may begin.
Good afternoon, Chair and members of the committee. For the record, my name is Elliot Mallon, E-L-L-I-O-T, last name Malin, M-A-L-I-N, representing the Creditors' Rights Attorneys Association of Nevada. CRAN is an industry trade group of attorneys who represents creditors before all courts in the state of Nevada. We regularly run into debt consolidation companies allegedly working on behalf of consumers. Outside of their contract with the consumers, these companies often have no ties to the state of Nevada. They regularly allow undisputed consumer debts to go into litigation, then require motion practice instead of immediately working to resolving these cases when there is no dispute and the debts are justly owed. We believe that the volume of unneeded cases overwhelms the judicial system in the state of Nevada. We encourage SB 261 as a way to incentivize pre-suit resolution, a benefit to the consumer and the courts. Thank you for the time today.
Thank you, caller. Caller with the last three digits, 232. Please press *6 to unmute yourself. Once again, caller with the last three digits, 232. Please press *6 to unmute. All right, we will move on. Caller with the last three digits, 364. Please press *6 to unmute. Once again, caller with the last three digits, 364. Please slowly state and spell your name for the record. You will have 2 minutes to speak and may begin.
Donna Armenta, DONNA-ARMENTA. I am calling on behalf of myself and my law firm, Donna Armenta Law. I am an attorney that does represent collection agencies as well as small business owners in collecting debts in the state of Nevada. I am calling because at this point in time, I have small clients such as cabinet installers, daycares, landscapers, pool people who come to me to collect debts under $3,000. They have these contracts in hand, and they have a provision in their contract that allows for awards of attorney's fees and costs, and I have to turn them down. I can't help them because I can't charge them. They're not willing to pay me an hourly fee just to come back and say, I'm not going to be able to recoup my attorney's fees. It wasn't until the law was passed that limited this, that essentially interfered with the contract provisions, and now says that the most I can receive is the 15% of the debt. With regards to the claims that I have filed, if it's just an undisputed default judgment, in general, I would be awarded about $500 to $800 from the court. But there are these debt consolidate companies and others that do dispute the debts and file answers even when there's not grounds for the answers. And I do have to litigate those to get to the judgment status. And in those cases, and when I do win on summary judgment, I'm usually granted about $1,650 or more in the justice court actions. So it really is a detriment and a process where debt collection is helping these small businesses keep on their feet. There is an economy need for debt collection for small businesses. And this limit to the 15% has overridden the statutory or the contractual provisions that these small businesses had been relying upon in order to be able to collect their debts. Thank you for your time.
Thank you, caller. Once again, caller with the last three digits, 232. If you can hear me, please press *6 to unmute yourself. Once again, caller with the last three digits, 232. Please press *6 to unmute. All right, well, Chair Scheibel, that caller is unresponsive, and with that, there are no more callers to give support testimony at this time.
Okay, thank you. we will move to testimony in opposition to SB 261.
Thank you, Chair Scheibel. To testify in opposition on Senate Bill 261, please press star 9 now to take your place in the queue. Once again, to testify in opposition on SB 261, please press star 9 now to take your place in the queue. Caller with the last 3 digits, 828, please slowly state and spell your name for the record. You will have 2 minutes to speak and may begin.
Good afternoon, Madam Chair, Vice Chair, members of the committee. For the record, my name is Sophia Romero, Sophia Romero, and I am a staff attorney in the Consumer Rights Project at Legal Aid Center of Southern Nevada. Thanks for the opportunity to comment here today in opposition of SB 261. SB 261 attempts to gut the protections that AB 477 put in place in the 2019 legislative session. While $500 might not seem like a lot of money to some, for one who's already behind on paying their debts is an extremely large amount. As Chapter 97 B only went into effect October 1st of 2019, the courts are interpreting this statute to only apply to contracts entered into after that date. So we have not even seen the results of the legislation as it currently stands because courts are not enforcing it as of yet. People are sued on small dollar amounts all the time. To give you an idea of the actual dollar amounts we're discussing, in 2020, debt collectors brought suits on principal dollars amount of $442.11, $328.19, $285.08, and $276.26. This was a small period in time by a single debt collector. These are small dollar amounts. These types of suits belong in small claims. There's plenty of information of small claims both on the Civil Law Self-Help Center website, and Legal Aid puts on a class every Friday that talks about small claims and how to do small claims. It's open to everyone in the community if anybody is having trouble navigating that process. If this bill were to pass, someone who is being sued on a $125 bill would, as a matter of law, be required to pay at least $500 in attorney's fees. That is 400% of the original amount of the debt in attorney's fees. This is not even including what they also have to pay in collection costs, which usually already includes the collection company's attorney's fees. SB 261 completely negates the entire purpose and intent behind NRS Chapter 97B. Raising fees such as collection costs and attorney's fees does not facilitate the collection of debt, but rather drives people towards bankruptcy. This bill attempts to target people who already don't have any money to pay, requiring them to pay more, and putting it into statute. These are small claims matters. Again, this bill is extremely detrimental to consumers by allowing and codifying predatory business practices, which is why we are opposition and we encourage the committee to oppose this measure as well. Thank you so much.
Thank you, caller. As a reminder, we are currently on opposition testimony for Senate Bill 261. If you'd like to provide opposition testimony at this time, please press star 9 now to take your place in the queue. Caller with the last 3 digits, 777, please slowly state and spell your name for the record. You will have 2 minutes to speak and may begin.
My name is Jamie Cogburn, Jamie Cogburn, Cogburn, with the Nevada Justice Association. We are in opposition to this bill. In fact, I'm looking on my computer screen right now at a lawsuit that was filed January of this year for $583 in principal amount, a collection agency fee of $291, attorney fees of $550, interest on the underlying amount of $564 because it's calculated at 24% interest per the contract, for a total due of $2,100.12. And that again is a original amount of debt with a prenatal doctor for $583. That was filed this year. So to say that these lawsuits will not be filed is blatantly false. This is filed by someone that's testified today. This is filed by a company that's part of the Nevada Collection Association. So nobody's going out of business, and as the person that went right before us with legal aid mentioned, the courts are handling these saying, hey, it only applies to contracts that went in that are signed after the fact. So we haven't seen any detrimental effect to anybody. And these are the type of cases that belong in small claims court where you can claim up to $10,000. These are claims for hundreds of dollars, not thousands. The number one debt in America per person is medical debt. On average in Nevada, 37% of the population is in collections. So a third of our population in the state, and this is before the pandemic, are in collections. And the number one reason is for medical debt, and the average median debt is $742. So to add $500 on top of that as a base for attorney's fees more than doubles it when you add up all the other costs and fees and collection fees associated with medical debt and the things of the sort. And for those reasons, the Nevada Justice Association opposes this bill. Thank you.
Thank you, caller. And with that, Chair Scheibel, there are no more callers to provide opposition testimony on SB 261 at this time.
Thank you so much. We will move then to testimony in the neutral position on SB 261.
Thank you, Chair. To testify in neutral standing on SB 261, please press *9 now to take your place in the queue. Once again, to provide neutral testimony on Senate Bill 261, please press *9 now to take your place in the queue. And Chair Scheibel, at this time, there are no callers to give neutral testimony.
Thank you. In that case, we are running short on time, so I'm just going to go ahead and close the hearing on SB 261 and encourage anybody who has additional questions or comments to have those conversations offline. And with that, we will move into the last bill presentation of today. I will open the hearing now on SB 6. I believe we are joined by John McCormick and Judge Bell to present this bill to us.
Good afternoon, Chair Scheibel and Senators. Thank you for having us here today. So 2 years ago, there was a statute passed to allow for high-risk protective orders in certain situations to remove firearms from people who are engaging in high-risk behaviors. I have handled all of those except for one where I had a conflict for Clark County. And in that 2-year time, we have had 33 applications. 25 of them were people seeking other types of protective orders. I appreciate Chair Scheibel has worked with, we've had some conversations about that and worked to come up with some ideas outside of statutory change to allow community applicants to still move forward and try to clear up that confusion. But there are some other procedural concerns that I have, having seen the applications that we have had come through. And so we're hoping to resolve some of those issues just to streamline the process to make sure that that we are balancing out due process rights and making the process a little more simple and clear for those who are filing applications. Of the 8 applications that were considered, there was a great deal of confusion because there's a process to apply for a 7-day temporary, it's called ex parte, but it's really a temporary or emergency order. And then there's a process to apply for an extended order. And it ends up with the court potentially having 2 evidentiary hearings in a 7-day period. And even some of our law enforcement agencies have struggled a little bit with the 2 different applications, which has resulted in some delays and some confusion that concerns me. So what we're seeking to do, I thank Chair Scheibel for her assistance with the amendments to get to where we're trying to be and changing some of the procedural things about this statute, is first of all, changing the word ex parte to emergency to just more clearly identify what that order is, that 7-day order, better reflect the nature of the order, reduce some confusion so it's clearer to a community member who may be looking at the statute exactly what it is that they're asking for with that short-term order, and also just more accurately reflect the proper legal term, because the order could be ex parte without notice to the other side, but it also could be with notice to the other side. So it doesn't really quite capture what we're looking at there. So one of the amendments is just to change that word ex parte to emergency throughout to better reflect that. We'd also like to streamline that process with the confusion with the two different applications. Have one application that can either be granted on an emergency basis pending a hearing, or not granted on an emergency basis and then just set for a hearing, to try to avoid that confusion and also eliminate the potential need for two evidentiary hearings in a really short period of time. There's also amendments to conform the language to use the term imminent risk throughout, not just the court finding, but also in the application part, to encourage supplemental documentation. It is tremendously helpful to the court when receiving these applications, particularly when looking at them on the emergency basis, to have additional documents to look at to see if there is a concern that warrants granting an order on such a short-term basis before there can be a full-blown hearing. This also streamlines some of the service issues that existed in the original statute. If somebody didn't apply for a temporary and extended, then there had to be service through the rules of civil procedure instead of service by law enforcement, which creates some safety concerns and also created actually some concerns, confusion for at least one of our law enforcement applicants who only asked for the extended order. And then we had quite a struggle to get the adverse party served through the rules of civil procedure before the application could be heard. And then finally, we're looking to remove the duty of the court clerk to assist. We are very happy to work with legal aid and community organizations to provide that sort of information, but it just exceeds typically what we would, it puts our clerks in a difficult position to have to give people advice on filing these kinds of documents. We always help people to actually do the filing, but we want to make sure that our clerks are not being put in the position of giving legal advice or giving advice on filling out the forms, which is typically beyond what we ask them to do. And I'm happy to answer any questions.
Thank you so much, Chief Judge Bell. We really appreciate you being here to help walk us through SB 6 and the amendment, which is posted on Nellis. And I see we already have some questions. I will start with Senator Settlemyer.
Thank you, Chair. I appreciate that. I was just curious, you indicated there was about 30 of these that were done in Clark County, Judge, and I was just curious, the current law is 14 days that their firearms would be returned to them. The bill changes it to 30. I was just curious, are you guys having a huge problem meeting the requirement of 14 days? I mean, it seems like a pretty big jump, 14 to 30. Is there a reason behind that?
My understanding, that was a request from some of our law enforcement partners that we worked on with this, but my understanding is that was being changed through the amendment, that was being eliminated, and we were just going to stay with the 14 days.
Okay, I didn't see the amendment, and I apologize about that.
In Senator Linda Bell, of the 8 that have been considered that were actually requesting high-risk protective orders, 3 have been granted in some capacity, and 1 was on a temporary basis only, not extended. The 2 extended. The adverse parties didn't oppose the order, so we haven't had a big issue in that regard.
Thank you, Judge. I appreciate the information.
And this is Senator Scheibel. I will just butt in to say that the amendment does reflect the 30 days as was originally requested in the original bill, but it's certainly a conversation we can follow up offline to make sure that conforms with everybody's intent and understanding. Senator Pickard.
Thank you, Madam Chair, and it's good to see you, Chief Bell. I want to start just by stepping back a little bit. I like the bill before the amendment better than after, and I'm wondering if you could describe, why we made the original, why the bill was drafted the way it was to make the changes we made, and why we undid much of that. If you could just speak to that for a moment.
Certainly. Linda Bell. So, Senator Pickard, thank you. The original concern that I had is that we have so many community applicants who have filed trying to get a domestic violence TPO, trying to get some other protective order for themselves personally, and not really understanding what this is. And of the 8 that have been considered, the 2 extended protective orders were both law enforcement. So we're having very minimal community applicants for the orders, and then those are not being granted because they don't have they just aren't able to meet the standards of the statute. So the initial thought was to just remove the community applications. There have been some concerns raised by the community that it may not always work to get law enforcement involved prior to filing this sort of application. And so Chair Scheibel and I had multiple discussions to try to figure out how to streamline the process and maintain the ability for the community, for basically family members, to apply if they do have concerns.
Okay, and in terms of those community applicants, did I understand that none of those where the community family member or otherwise submitted the request, that those were granted in any case?
In Clark County, there was one temporary application that was granted to a victim of domestic violence who had been in a cohabitating relationship, but because when the hearing on the extended happened, she no longer qualified as a family member, the extended order was denied. That was actually the one that I didn't hear that one because I had a conflict.
And that makes sense because the TPO standard is fairly narrow when it comes to the family member or cohabitant. Right. And so, I mean, I recall in some detail about this discussion when it was first passed and how this could be abused. It sounds like we haven't experienced that family members aren't using this as a means of obtaining an advantage, for example, in a domestic case. Have you ever seen a case where the application was really based on insufficient evidence to even grant it in the first instance and felt that they were less than candid in their application?
Linda Bell, with respect to the first part of that, yes, we've had 5 that were denied because of insufficient information provided or insufficient evidence to establish what's required under the statute. I couldn't say that I felt that any of those were being sought for improper purposes. They just didn't meet the standard. So you have to show that there's no less restrictive means and that there's an imminent risk. And both of those things are fairly hard to establish.
And in the cases, and I appreciate that, thank you. And in the cases where they were granted, was the adverse party found to be mentally disturbed, or were these just people that expressed their distaste in violent ways? How would you characterize these adverse parties?
Linda Bell, we had one of each. We had one gentleman who had some mental health issues. We had one gentleman who posed a high risk for other reasons. Okay.
All right. And then finally, when we're talking about the orders, We've broken this into the two pieces similar to a TPO, where we've got the emergency order that's held, and is that, I'm a little confused because as I'm going into some of the new language, it looks like there is no requirement for notice, but there is an expectation for a hearing, and that hearing can be telephonic. Now that we've had lots of experience with telephonic hearings, do you think that you're able to, as the judicial officer, that you're able to get enough information, given that 80% of communication is nonverbal? Are you getting the kind of responses you need and the insight that you would typically get? Is that sufficient over the telephone?
Linda Bell. So the telephonic application allows law enforcement to call me 24/7. We have not had that happen yet. All of our applications have been in writing, but certainly that's how we actually do our search warrants, mostly electronically now, but we do some telephonically. And I do think that's I think that absolutely gives us sufficient information. As the statute stands right now, there's no notice requirement. In fact, it's even called ex parte through the whole statute, but there's no notice requirement for that emergency application. It's whether they can establish the imminent risk and the need on an emergent basis to grant that short-term order before there can be a full evidentiary hearing. But there has to be, if that emergency order is granted, there has to be a full hearing within 7 days. It's a very short time frame.
Right, and certainly better than what we see with TPOs. And I do appreciate that. And as someone who is also indirectly disturbed by those early morning warrant calls, I am glad to hear that you're not getting them at midnight. That was my last question. I do have some other concerns, but I think they're minor, relatively speaking. So thank you, Madam Chair, for your indulgence.
Sure. Any other questions from the committee? I don't see any, so we will move now to testimony in support of SB 6.
Thank you, Chair Scheibel. To testify in support on Senate Bill 6, please press star 9 now to take your place in the queue. Once again, to testify in support on Senate Bill 6, please press star 9 now to take your place in the queue. And Chair, at this time, there are no callers to give support testimony.
Thank you very much. We will move to testimony in opposition to SB 6.
Thank you, Chair. To testify in opposition on Senate Bill 6, please press star 9 now to take your place in the queue. Once again, to testify in opposition on SB 6, please press star 9 now to take your place in the queue. Caller with the last 3 digits, 502, please slowly state and spell your name for the record. You will have 2 minutes to speak and may begin.
Yes, this is Dan Reed, D-A-N-R-E-I-D, Western Regional Director with the National Rifle Association. We're here in opposition today to Senate Bill 6 as we oppose the underlying red flag law in the 2019 session. And obviously today we've been dealing with a pretty substantial amendment to this bill, and we've been going through it. And we do still have concerns with the amended language here, specifically looking at section 1.3. We're looking at we see that regardless of the outcome of the new emergency or coined emergency order, there's going to be a hearing on the extended order. We have some questions on that. If an emergency order is not granted, why have the extended order? And the only time that the court it appears to have the discretion to not do that is if the applicant withdraws their application. Also, we have concerns with section 8, where with the time to surrender, when the underlying bill was heard, we outlined our concerns regarding surrender and providing notification to the court as how that could implicate someone under Fifth Amendment grounds. But also there's a reduction in time to surrender those firearms from 72 to 24 hours.
And then also there was a question regarding this 14 to 30 day for the time law enforcement has to return the firearms. This seems like an incredibly long amount of time, especially if someone is only subject to an order like this for a couple days for law enforcement, then to potentially not return a firearm for up to 30 days where someone's deprived of their constitutional rights during that time. So with that, we're in opposition. We'll stand for any questions. Thank you.
Thank you, caller. And as a reminder, if you've recently joined us, we're currently on opposition testimony for Senate Bill 6. If you'd like to provide opposition testimony at this time, please press star 9 now to take your place in the queue. Caller with the last 3 digits, 407, please slowly state and spell your name for the record. You will have 2 minutes to speak and may begin.
Thank you, Broadcast Center. Thank you, Chair Scheibel. For the record, Randy Thompson, RANDI-THOMPSON, representing the Nevada Firearms Coalition. On behalf of the over 45% of Nevadans who are law-abiding firearm owners in the state, we are opposed to SB 6 and the proposed amendment. And I will just say ditto to my colleague, Dan Reed, since you guys have a busy day. Thank you. Thank you, Chair.
Thank you, caller. And with that, Chair, there are no more callers to provide opposition testimony at this time.
Thank you so much, Mr. Kyle. We will now move to testimony in the neutral position on SB 6.
Thank you, Chair. To testify in neutral standing on Senate Bill 6, please press star 9 now to take your place in the queue. Once again, to provide neutral testimony on Senate Bill 6, please press star 9 now to take your place in the queue. And Chair, at this time, there are no callers to give neutral testimony.
All right, thank you. I will now close the hearing on SB 6. That is the last bill on our agenda for today. That brings us to the last item on our agenda for today, public comment. Mr. Kyle, is there anybody wishing to give public comment on the line?
Thank you, Chair Scheibel. The phone lines are open and working. However, there are no callers to give public comment at this time.
All right. In that case, that concludes our meeting. We will be meeting again tomorrow at 1 p.m. I know that some other committees may be adjusting their schedules, but we will plan on starting at 1. And until then, we are adjourned.